It's a sunny afternoon, and you're out horseback riding. Suddenly, your horse stumbles. You lose control and crash to the ground. You're in pain, you're confused, and struggling to move. Moments later, paramedics arrive. They check your injuries, they start treating you, and they rush you to the hospital. But later, you wonder, did you actually agree to any of this? Should they have asked first? That's exactly what happened in Battrum vs. British Columbia, a case that shaped how medical professionals approach emergency care. In this case, we'll explore the concept of implied consent, when treatment is provided without explicit permission, often in emergencies. But this case isn't just about legal arguments, it's about real people, real situations, and real dilemmas. What if you're unconscious? What if you're confused and unable to answer? Should paramedics risk waiting, or should they act in your best interest? Let's dive into the details and see why this case matters to you in the healthcare system. Let's start with the facts. Here's what went down in Battrum vs. British Columbia. Miss Battrum suffered injuries after falling from a horse and called 911. A paramedic, Mr. Reggs, provided medical assistance at the scene and during transport. Later, Miss Battrum claimed she had not consented to the treatment and accused the paramedic of battery. The case was brought before the Supreme Court of British Columbia in 2009. But what exactly is battery in legal terms? Battery refers to harmful or offensive physical contact without consent. In healthcare, this can be a serious allegation. After all, medical professionals must respect a patient's right to refuse treatment. The big question was, did Miss Bathroom actually consent to the treatment? From her perspective, she never verbally agreed to care. However, from the paramedic's view, she didn't try resisting help and allowed herself to be transported. The court now had a difficult question to answer. If there was no explicit consent, could this be considered battery? In legal terms, implied consent is often determined based on the patient's actions, the urgency of the situation, and whether a reasonable person would consent under similar circumstances. In the end, the court ruled that Ms. Bethroom had given implied consent. She accepted help from the firefighters, she did not resist treatment, and agreed to be transported. This ruling matters because it clarifies a fundamental issue in emergency medicine. When is it okay to treat a patient without explicit permission? Now let's talk about why this case matters to individuals, both patients and medical professionals. For patients, this case reinforces implied consent, meaning if you don't object, you may be considered to have agreed to care. This is particularly important in situations where patients may be unconscious, disoriented, or unable to communicate their wishes clearly. But here's the concern. What if someone doesn't want treatment, but they're too weak or confused to say no? Would it be fair for paramedics to assume consent in those situations, or does that risk violating patient autonomy? For healthcare providers, the ruling protects first responders and paramedics from legal action when acting in emergencies. This means it ensures they can do their job without the constant fear of being sued for simply trying to save a life. Looking at both sides, it raises a key ethical debate. How do we balance patient autonomy with the need for immediate medical care? This case isn't just about legal precedent, it touches on a deeper ethical dilemma. How do we respect patient autonomy while ensuring timely, life-saving treatment? Beyond this single case, Bethune v. British Columbia set a legal precedent. It ensures healthcare professionals can act in emergencies without fear of being sued. It defines when implied consent applies, shaping laws on emergency care. It reminds us of the delicate balance between medical ethics and legal responsibility. This also opens the door for future cases to explore the boundaries of implied consent in emergency situations and how healthcare providers should navigate them. This case isn't just about one person. It has shaped how emergency care is handled across Canada. It also sets the stage for ongoing discussions about how much autonomy patients should have in emergency situations, how healthcare providers can balance ethical and legal responsibilities, and whether future laws should establish clearer guidelines for consent in life-threatening scenarios. Additionally, as healthcare evolves, so does the question of consent. Could technology like digital health records or wearable alerts help clarify a patient's wishes in emergencies? So, let's go back to that horseback riding accident. If you're in Miss Bethrum's position, would you feel that your rights were violated, or would you be grateful for the care? That's the ethical challenge of emergency medicine, balancing patient autonomy with the urgent need to act. Some argue that waiting for explicit consent could cost lives. Others worry that implied consent could be misused, leading to unnecessary or unwanted medical treatment. This debate isn't just theoretical, it affects real people every day. Whether you're a patient, a paramedic, or a policymaker, understanding implied consent helps shape a healthcare system that reflects both ethics and urgency. What do you think? Should emergency responders always wait for verbal consent, or is acting in a patient's best interest enough?